Yes, Mr. Marriott.
My Lords, I appear for the Secretary of State this morning, who is the appellant before this court. My learned friend, Mr. Collins, appears for MU, who is the respondent.
Yes.
My Lords, AL and BNP are two major political parties in Bangladesh. In 2009, AL came into power and Sheikh Hasina became the Prime Minister of Bangladesh. MU says that he was involved in BNP politics in Bangladesh until 2016, when he came to this country as spouse of a British citizen. He was granted leave to remain until 2021. In 2020, my Lords, he committed a serious crime. My Lord knows that he saw a vulnerable female who was intoxicated and defenseless. He raped her, causing serious psychological harm and infecting her with a sexually transmitted disease. He received a sentence of 6 years imprisonment. When the Secretary of State served a notice of intention to deport him from the UK, he made an asylum claim on the basis that he was at risk in Bangladesh. His asylum interview contained several discrepancies and gaps, so the Secretary of State refused his claim. On appeal, a judge of the First Tier Tribunal held that he was excluded from protection under the Refugee Convention because of his criminal conviction. His presence, the judge held, constituted a threat to the community. The judge allowed the appeal on Article 3 grounds on the basis that he would be at risk in Bangladesh.
Can I just ask you one technical
Yes.
point, which is puzzling me? You will know the answer, and I ought to know the answer. The judge described herself as dismissing his Refugee Convention and humanitarian protection claims, but allowing his appeal on Article 3. I had it in my head that the difference between humanitarian protection and asylum was Article 3. So she shouldn't have dismissed his humanitarian protection claim. That's actually what she was allowing.
Yes.
Am I right about that?
Yes.
Good.
The judge allowed the appeal, as my Lord knows, on Article 3 grounds.
Yeah.
Now, so far as the discrepancies and gaps in the interview are concerned, the judge held that his answers in the interviews would have been affected by his mental health. The Upper Tribunal upheld the First Tier Tribunal's decision, holding that it contained no error of law, and this is the second appeal to this court. Now, my Lords, the First Tier Tribunal made its decision in November 2023. The Upper Tribunal made its decision in April 2024. Shortly thereafter, in August 2024, AL's government in Bangladesh came to an end. There is presently an interim government in place, headed by Dr. Yunus. So the factual basis on which MU advanced his claim has now disappeared. Now, I shall seek to persuade you, my Lords, that the judge made two errors of law.
Well, assuming those are the two that are pleaded in the grounds, do you accept that Lady Justice Andrews was right to say that the change of regime in Bangladesh is of no relevance to this appeal?
Well, yes.
Maybe I'm coming to the question of what happens if the appeal succeeds.
Precisely, yes. Yes.
But we have got to decide whether the First Tier Tribunal made an error of law on the facts as found by it, which effectively related to the political situation pre-2024. If we allow the appeal, I don't want to get ahead of ourselves, but just to understand the potential relevance.
Yes.
If we remit for to either the FTT or the Upper Tribunal in a primary decision-making role. Am I right in believing that they will have to decide whether whether deportation would be in breach of his Article 3 rights on the basis of the facts as they are at the time of that decision, i.e. on the remittal hearing?
Yes, Lord, I will address you on that question shortly.
We'll park it for the moment.
Yes, there is a short submission that I will make, which is that if you find that there is an error of law in the First Tier Tribunal's decision, and that decision should be set aside, in my respectful submission, there is no point in remitting this appeal to the First Tier Tribunal. Of course, you'll hear from a learned friend, but on the basis of the objective evidence, as it now stands, the outcome is inevitable.
Okay, well, we'll hear that submission when we get there, but I just really intervened at that point because you mentioned the change of regime, and I just wanted to know to what extent it was material. And the answer is, you say it will be material by one route or another.
Yes.
On remedy if we allow the appeal.
Yes.
Remedy's the wrong word, but consequential orders if we allow the appeal. But you accept that on the primary question before us as to whether there's been error of law, it's irrelevant.
Yes.
Yes. Can I just, while I've interrupted you, ask one other question? Suppose we dismiss the appeal. I don't think this is relevant, but I just want to identify what the position would be. There would be clearly tools available to the Secretary of State to make the original her original decision to deport would have been quashed on that hypothesis, but she can make a fresh decision on the basis of the change of circumstances. That must be right, mustn't it?
Yes, my Lord. There is a controversial, I say this with respect, controversial line of authority as to whether the Secretary of State can decline to give effect to the tribunal's decision on the basis of change in the circumstances. But there are tools, yes, that would be available.
We don't need to but whatever happens, certainly the Secretary of State's position is that even if she loses this appeal, she doesn't have to put up with him staying if she can show he's no longer at risk.
Yes.
But you obviously prefer to win this appeal.
Of course, yes.
Thank you very much. Right, I'll let you get on to where you're going to go next.
So two short grounds. First, the judge's approach to the country evidence was legally flawed, and she made a decision that was not open to her. And second, the judge erred as to the effect of MU's mental health. Now, these two grounds, my lords, raise connected points, very short points, so subject to any observations. What I propose to do is to show you the country evidence first, and I will then take you to the decisions made below and make some very brief submissions on the two grounds. So country evidence first. If you have the authorities bundle, Lords, behind tab 1, you have country policy and information note that was published in September 2020, version 3.
Sorry, just before we get into this, did you know, is the air conditioning on? It seems pretty hot in here. Right, thank you very much. I don't know whether, I don't know whether anyone else is feeling it. We'll cope, but normally the air conditioning is very effective. But,
yes, it is.
There is a dial on the bench. I'm not sure whether it has any effect.
To the right. Yes. Well, mine says it's pointed firmly to minus, which presumably means cold. But don't worry, we won't waste time about it now. It'd be just worth checking then. You've got any technological? Yes. If Councillor, if it's as hot down there as it is up here, Please feel free to take your wigs off.
Very good.
But don't feel obliged. Right.
Tab 1, you have Country Policy and Information Note, version 3, published in September 2020. Now, this is the objective evidence that was before the First Tier Tribunal and the Upper Tribunal. And can I just quickly show you the relevant parts of this document? If you go to page 8 of the bundle, you will see a heading, risk, and a subheading, state treatment. If you look at paragraph 2.4.1, you will see that it says that there are two main political parties, AL and BNP, and both said to have several million members. So BNP has several million members. There is then a discussion as to the country situation from paragraphs 2.4.2 to 2.4.6, and the conclusion of that discussion is at paragraph 2.4.7, which is at page 9. And this is the paragraph that I would respectfully invite my lords to look at. In general, the paragraph says, low-level members of opposition groups are unlikely to be of ongoing interest to the authorities and unlikely to be subject of treatment that is sufficiently serious by its nature or reputation to amount to persecution. Persecution, as we know, is a strong word, and that is the objective evidence. So the task of the decision maker, where a person says that he is at risk from the state, is to decide whether that person is a low-level member or a member with a particular political profile.
Yes, there's the second sentence as well.
The second sentence, yes. Opposition party activists, particularly those whose position and activities challenge and threaten the government. The first part of it. Second, raises their profile, may be subject to treatment, which amounts to persecution. So not every member of BNP is at risk of persecution. That would be an extraordinary conclusion, given that there are several million members of BNP in Bangladesh. It really depends on that person's profile.
The whole of this section, although there's a passing reference to non-state actors in 2.4.7, but this is effectively about state treatment. It's about whether they would be of interest to the authorities.
Yes, but it would be perhaps fair to MU just to point out, Lord, as you said, that the second sentence in paragraph 2.4.7
yes,
refers also to non-state actors.
Mm-hmm.
But Mr. Malik, the task of the decision maker is surely not to pigeonhole somebody as to whether they're a member of a group or whether they're an activist in a group. The task is really what's set out in 248, which is to decide in the individual case whether somebody has shown that there are particular factors specific to them which would place them at real risk. I mean, that's what has to be done, and in considering that, individual attention has got to be given to the degree of involvement in politics that the evidence shows. I mean, it's not about pigeonholing people, is it? Because these descriptions are too vague.
That is absolutely right, my lord, and that, in my respective submission, is perhaps clear from the word in general at 2.4.7. So the general position is that someone who is a low-level member is unlikely to be at risk. But a person may say that although I'm a low-level member, there are particular features that places me at risk. But the submission that I make, my lord, is that the fact finder is obliged to decide what a person's profile is, whether there are particular specific features that would
that's
place
what I'm
that person at
challenging.
risk.
No, if you, this isn't a profiling test. It's a test which has got to weigh up all the factors, and it may lead you to the view that this person, because of the degree of their political activity, is at risk of serious harm. Or it may lead to the conclusion that this is just one of a very large number of people who take an interest in politics and aren't at particular risk. But I'm challenging the helpfulness of what I think you've alighted on, which is profiling, and saying that there are one or that they're the other. Of course, 247 may help you to reach a conclusion about what's involved in 248, but I may be wrong about this, but
Yes.
I think there's a risk in saying that you should choose that they're either in the first sentence or the second sentence of 247.
Lord, I shall, of course, seek to persuade you that it's absolutely essential for the decision makers to form a view as to a person's profile. I'll explain why that is essential. Of course, in asylum cases, the first question for the decision maker is to decide whether the applicant is at risk. Now, but the fact that a person is at risk is not the end of the matter. The decision maker will then have to consider two other questions. Second question is whether the person who is at risk can approach local authorities for protection. The objective evidence, and I'll show you the relevant parts, then says that in considering that question, a person's profile becomes relevant. The third question then is whether, if a person is at risk, if the state is unable or unwilling to provide protection, whether that person can then internally relocate to another place, another safe place within the country of origin. And the objective evidence tells us that a person's profile is also relevant to that question. So one way or another, my submission is that it is essential for the decision maker to form a view as to a person's profile.
Well, I'm not sure we need to spend a lot of time on this, but you seem to be attaching a lot of weight to the concept of profile as if it has some technical meaning. It's surely just that bundle of characteristics that is relevant to whether they're at risk, relevant to whether the authorities will give protection, and relevant to whether they can internally relocate. And there'll perhaps be slightly different characters, considerable overlap,
yes,
but some characteristics are more important than others for each question.
I have no difficulty with that.
I'm not sure really we're arguing about that much.
Yes, the reason, Lord, why I use the phrase profile is because it is a sort of term of art that is used in this jurisdiction, in the country evidence, in country guidance cases. Lord, the Vice President is right that when one uses the word profile, it actually means characteristics of a particular person or the involvement.
I mean, just a point in passing, since you mentioned country guidance, Mr. Collins says we must beware of treating a CPIN as having the same status as a country guidance.
Yes.
And that some of your submissions seem to suggest that, some of your written submissions seem to suggest that's what you were doing. What do you say about that?
Well, of course, this isn't country guidance. The judge, in my respective submission, correctly assessed the appeal against the information that is set out in CPIN. Yeah. And it is common ground that the judge should have done that. And if the judge's approach to this evidence is flawed, then that would be an error of law. So this is 2.4.7, which is about risk. If you then go to page 10, you'll see a heading protection. So assume that someone is at risk from non-state actors. What happens then? 2.5.1 says that where persecution, the risk arises from the state, then of course common sense tells us that that person cannot seek protection of the local authorities. But 2.5.2 and this is this case, where a person's fear is of persecution and or serious harm from non-state actors, the decision makers must assess whether the state can provide effective protection. And this is premised on well-settled legal principles. Must is the word that I respectfully emphasize. Now, if you then go to the next page, Lord, page 11, you will see that word profile is used again at paragraph 2.5.4. The willingness
6.4, 2.5.4, sorry.
Yes,
right.
2.5. The willingness of the authorities to protect will depend on the profile of a person. But by profile, as I said, what is meant is the individual characteristics. If there is a risk from non-state actors, and if the state is unwilling or unable to provide protection, you then go to the third question. You'll see a heading, internal relocation.
I mean, I'm sure my Lord will have seen this, but the point that's made in 2.254 is the very point that I was trying to make a moment ago. But, I mean, when
Yes.
profiling may be of assistance in making the decision, but it's not the ultimate question. Anyhow, there it is.
Yes, I mean, if profile means, my Lord, if as Vice President said, if profile really means, and I think this is the point that is troubling you, if the profile means individual characteristic or what a person has done in politics, then my submission is that is relevant and it is essential for the decision maker to grapple with it. Just very quickly, 2.6.3, this and 2.6.2, this concerns internal relocation. Where the risk is from the state, a person cannot be expected to relocate elsewhere. But where the risk is from non-state actors, such as supporters of a rival political party, then relocation is likely to depend on the profile of the persecutor. How powerful the persecutor is, as well as the facts of a particular case and the individual circumstances. And again, my Lord, we'll see the word profile of the person.
Yes, the judge didn't refer to anything in section 2 apart from 2.4.7.
Yes. Yeah. And of course, that is one of the points that I will make shortly. So this is the evidence about risk, protection, and internal relocation. Now, if you then go to page 27 of this document, you will see a heading just right at the end of that page, Bangladesh Nationalist Party, BNP. So under that heading, my Lords will find evidence as to the party. And if you look at the first paragraph, this is 5.1.1, last sentence, you'll see that BNP is the main opposition party in Bangladesh. 5.1.2 tells us, my Lords, that it was founded in 1978. In the next paragraph, you have the names of top leadership. The leader is Khalida Zia, and the acting chairperson is Tariq Rahman. So this is the top leadership. If you go to the next page, page 29, and if you look at paragraph 5.1.6, you'll see that there was a boycott, but then there were 6 BNP members won their seats and 4 decided to take oath. So top leadership and 4 members are obviously people of particular profile. Now you'll then see a heading, local branches, and under that heading you'll see evidence as to the structure of BNP. So the top decision-making body is the Standing Committee. This is 5.2.1. There is then a discussion as to various offices and structures. And if you look at page 30, 2 bullet points, you'll see that 2 particular offices are named. The first is Organizing Secretary. Now, this is the 3rd most influential position after the top leadership, the President and the General Secretary. And then Publicity Secretary, a relatively low-level position within the branch. Go to page 31, you'll see 5.3.2. The evidence suggests that membership stood at a few million. This respondent MU, as I will explain shortly, is not an office holder of BNP. His case is that he was an office holder of BNP's student wing. If you go to page 32, you will see a list of groups, and 5.1.4, the first bullet point is JCD. This is the student wing. Just one last paragraph in this document. If you go to the next page, page 33, you'll see evidence about JCD. And the evidence is that it is a completely separate organization from the BNP. It has completely separate executive committees from the BNP structure and leadership. It structures its executive committee in a similar way to BNP, but there is no overlap between 2 organizations. So this is the evidence that was before the decision makers below. If you go to tab 2 of the authorities bundle, you will see the updated version of country policy and information note. This was published in December 2024.
So what, that's about 9 months after the change of regime?
Yes. Yeah. I'll very quickly show you 2 passages from this document.
To situate, I'm sure this will be interesting, but this is after the tribunals have spoken in this case.
Absolutely.
This will only be relevant to the submission that you flagged about what we do if we find an error of law.
Yes. So given that I'm showing you country evidence just to avoid repetition, I'll show you 2 passages from this document.
Okay.
Now, if you go to page 77, you'll see a heading risk. Paragraph 3.1 is risk from state. And the position now is that leaders, members, and supporters of BNP are unlikely to face persecution or serious harm from the state. AL is no longer in power. The other paragraph that I'll respectfully invite you to read is paragraph 3.2.1, which you have at page 80. Leaders, members, and supporters of political groups are unlikely to face persecution or serious harm from non-state actors.
Yeah.
So this is the objective evidence as it currently stands. Now, can I then just take you to the decisions below and make submissions on the 2 grounds?
Yes.
Lord, if you go to the appeal bundle, the first decision that I'll take you to is the decision by the Secretary of State refusing the asylum claim and making the decision to deport MU. And that decision is at page 59 of the bundle.
Yes.
Can I just ask this as a general question. If one's going to anonymise people, why do you anonymise them by their initials?
There is a practice direction of this court saying that in protection cases, you should pick the first letter of the first name and then the surname, in brackets, the name of the country.
You're nearly always right, Mr. Malik. I assume you are. That does slightly surprise. I knew that was a practice direction saying you must anonymise. I didn't know it went to the detail of saying how.
It does, and I'll provide you a copy if you wish in due course. Yeah.
Yes. Well, thank you.
Yeah. But do you need a copy of the practice direction?
No, it's for another day, I think, but
Yes.
it just does seems like a surprising way to go about anonymising in a case where it's being said that there's a real threat. Because, I mean, once the proceedings are over, the consequence may be that the person will go into the environment that they said there was a threat.
Yes.
Anyhow, there we are.
So page 59, you have the decision. If you look at page 5 of that decision, you will see the sentencing remarks. And you'll see that the sentencing judge explained the nature of the offense. And in the last paragraph, as to why the sentence of 6 years in custody was appropriate. So the victim was a vulnerable female who was intoxicated and defenseless. Instead of assisting the victim was raped. There was serious psychological harm, infection with sexual transmitted disease, and the nature of the offense was humiliating and degrading. No remorse was shown by MU. That was the reason why the Secretary of State issued a certificate under Section 72 of the 2002 Act. You have that certificate at page 61 of the bundle, saying that he was excluded from the protection under the Refugee Convention. The decision maker then summarizes the claim and then considers the claim from paragraph 18 onwards. Page 64, you'll see a heading consideration of claim. The decision maker cites the objective evidence, including the document that I've shown you. Can I just take you straight to the passages that are relevant to the two grounds? You go to page 70 of the bundle, paragraph 37. This is where the decision maker analyzes the evidence given in the interview. And the first point the decision maker makes is that the information given in the interview as to when MU left the school was inconsistent. This was relevant because he was saying that he was a student leader. So he said at this paragraph 37 that he left school at 16 or 17, but then that was inconsistent with what he said thereafter, that he left school when he was 15 or 16. Now this is relevant for the reasons the decision maker gives subsequently in the decision. Because paragraph 39 is a record of the evidence as to the death of MU's father and the fact that he started working when his father passed away. And then the overall conclusion of the points is at paragraph 42. Because of the inconsistent information as to when MU left high school and became involved in politics, that was inconsistent with his account of started working shortly after the death of his father. the Secretary of State took the view that that damaged his credibility. So that was the first point that was made, that there was inconsistent information about how he entered into politics. More substantial points are on the next page, page 71. So MU is a person who says he's deeply involved in politics, was an active member of BNP student wing. If you look at paragraph 43, when he was asked as to what does BNP flag looks like, he said red and white and wasn't able to describe the logo.
What part of the FTT decision is this addressed to? Are you challenging a finding of fact that's made by the FTT?
Yes. So that is ground 2. I'm showing you, my lords, the discrepancies and gaps
yes,
in
but
the
there's
evidence.
always a danger that when we're looking through these pieces of information in a much wider field, that we don't get the whole picture. I just need to understand what is the finding that the FTT made that you are challenging in this ground of appeal.
So this is relevant to my second ground. The First Tier Tribunal said, in short, that the answers given by the appellant, by MU in the interview, would have been affected by his mental health presentation. And I say that that is an error of law. It is therefore, in my respective submission, relevant to understand what those discrepancies and gaps were. So apart from, this is paragraph 43, apart from the flag, he was asked when BNP was founded. He said 1975, but we know from the objective evidence that I've just taken you to that it was founded in 1978. Now, if you then look at paragraph 44, you will see that second last sentence, MU was unable to remember the anthem of BNP, saying that he was out of touch. The conclusion is of these 2 points is paragraph 45. The Secretary of State says that if you're actually active in BNP politics, if you actually held prominent positions, then you would have been able to remember these very basic details. And the fact that you haven't been able to answer these basic questions means that your account is not credible. The decision maker then considers the substance of the account. Now, MU did not suggest that the risk was from the state. If you look at paragraph 46, he alleged that the fear is from unknown members of Awami League due to his involvement with BNP. Paragraph 47 is a summary of his account that when he was in Bangladesh in 2019, he was attacked by unknown individuals who were sporting AL. And the incidents were not reported to police. So this was MU's account. The Secretary of State, of course, rejected the account, but in the alternative, considered the issue of internal relocation. It's page 73 of the bundle. And the alternative point the Secretary of State makes at paragraph 62 is that if there are any problems with non-state actors, then it is open to MU to internally relocate to another area. And that would not be unduly harsh. So this is the Secretary of State's decision. If you then go to the First Tier Tribunal's decision, that decision starts at page 47. if you look at paragraph 7, you'll see a summary of the issues, and you'll see why there is no Article 8 point in this appeal for the reasons at paragraph 8. MU quite properly accepted that there are no very compelling circumstances for the purpose of section 117 C6.
Could I just understand before it's the previous point, but are you seeking to disturb the FTT findings that, contrary to the decision letter, there was an attack?
No.
No. So whatever the outcome of your appeal, though the FTT's conclusion about that will be preserved and not revisited.
About the attack, yes.
Yes.
So there's no challenge to that factual finding there.
Okay. I'd understood that, but I just wanted to check that was the case.
So paragraph 8, you have the concession. Now if you then go to page 49, you'll see heading section 72 of the 2002 Act. And under that heading, the judge addresses the question of exclusion. The conclusion is at paragraph 25. What the judge found particularly troubling about this case was that the appellant was that MU maintained his innocence. And just 3 months prior to the substantive hearing, stated that it was the victim who instigated what
I see forensically why you want to emphasize all this, but it's not relevant to the issues before us, is it? If there's no balancing act required by Article 3, he either is or isn't at a real risk of serious harm. And if he is, then that's it.
That's it, yes.
Okay, very well.
Yes, yes. I mean, that of course, it's important to emphasize with this fact, that does not mean that a person's offending is completely irrelevant to the general issue of protection under the Refugee Convention and that person's entitlement to stay in the country. If a person has committed serious crime.
Of course, it's relevant to the Refugee Convention,
yes,
because of the way the Refugee Convention is drafted. But for the purposes of Article 3,
it is of no relevance, yes, absolutely, Milord, you're right, yes. Then again, this is simply to provide you the context. If you look at the concluding part of that paragraph, you'll see that MU is assessed as posing serious harm to women, particularly those who he considers to be vulnerable. There's a high risk.
Yeah.
You then see a heading, Article 3 claim. And under that heading, the judge considers the claim on that basis.
Yeah, sorry, just it's the end of paragraph 26 that is the error that you agreed with me was an error of categorization,
yes,
where she says she finds she cannot benefit from humanitarian protection. That's not strictly correct, because Article 3 is humanitarian protection. That's what I was putting to you earlier.
It is, yes, yes.
I think so.
Yes.
But you and Mr. Collins are doing this every day. If you think I've got it wrong, do say.
Yes.
Delete that sentence, but it doesn't affect.
No, it's purely so that we can express ourselves correctly in the judgment.
Yes. You'll then see a heading, Article 3.
Yeah.
And paragraph 29 is a summary. Paragraphs 29 and 30 are a summary of the account that MU gave in the interview. It's 29 that he was involved in BNP politics. He was a member of the union committee of the student wing, became the president of the union. This is student wing, not BNP. You'll see that.
I don't recall. Is there an explanation of what the Tana Committee is in the CPIN or anything we've seen? Everyone seems to sort of just refer to it, but I haven't picked up what it is.
I'll just double check the position shortly. I'm not sure if there is.
No,
an
it may not
express
matter,
reference to
but
TANAC maybe.
if it's of any significance, but I'd like to know.
Yeah.
But okay.
No. But I've shown you the relevant parts of CPIN.
Yes, it's either there or it isn't. Yep.
Yes. So of course, what we know from paragraph 29 is that MU is not in the top leadership. He is not in the decision-making body, the committee, etc. He says that he's at BNP. Paragraph 30 is a summary of the attacks. Yes.
A very reliable source of information tells me here that it's an administrative area, originally meaning a police station.
Yes.
And so it's a local administrative unit.
Yes.
Of some kind would be the Tana Committee.
Very helpful. Thank you.
Good. And then paragraph 30 is a paragraph that summarizes the account of the two attacks. So it's quite clear that even at the appeal stage, MU was saying that he was at risk from non-state actors, from supporters of Awami League. But what is missing, of course, from this summary are the passages, paragraphs in the decision letters that I've shown you, identifying discrepancies and gaps in the evidence. If you then go to next page, page 52, you'll see at paragraph 32 a summary of what an expert report stated. That he has been an active member and supporter of BNP, a member and supporter of BNP. That's what the expert said. Now, his evidence at the appeal hearing, written evidence, is summarized at paragraph 33. He did not say in the written evidence that is summarized at that paragraph, actually quoted at that paragraph, that he had a particular profile at BNP. He said that he was deeply involved in politics and referred to some documentary evidence. Paragraph 34 is the summary of his oral evidence. And if you look at the middle of that paragraph.
Sorry, the documentary evidence, is that the documentary evidence she refers to later and says he was given an opportunity to produce it but didn't? What am I?
No. So
that's different documentary evidence.
Yes. So these were certain photographs that is discussed subsequently in the decision. Paragraph 39. I'll take it at that.
Yes,
paragraph.
I see.
And certain
Okay.
use
Yeah, no, that's fine. Carry on.
Yes. So paragraph 34, middle of that paragraph, you'll see that he last attended a demonstration in the UK in 2018 or 2019, and he did not attend any other demonstrations. And what is relevant in particular is that he was not a member in the United Kingdom. So he was a member of BNP in Bangladesh, he said, but not in the UK. And again, you'll see that the risk comes from non-state actors. If you then go to page 53, the expert who gave evidence that he was an active member and supporter of BNP, he had been an active member and supporter of BNP, also gave evidence as to MU's mental health. And that evidence is summarized at paragraph 37. There's no challenge to that paragraph, and I accept that it accurately summarizes the evidence.
Sorry, I hadn't picked up, though, that Dr. Kashmiri also gave evidence as to his membership.
Yes.
I'm so sorry, yes, I should have. I see, but yes. I didn't really take it in. the reason I didn't take it in at 32, it's not I think he's been put forward as an independent witness of that, it's merely that's the history he had given.
Yes.
Yeah.
Paragraph 37, Dr. Kashmiri says that MU has major depressive disorder. And that information and that diagnosis was based on the information that MU provided together with monthly progress reports and the examination. So the diagnosis is of major depressive disorder. There's no challenge to that. You'll see that the presenting officer did not challenge Dr. Kashmiri's qualifications or experience and did not dispute the diagnosis. I do not seek to depart from that. The judge then considers certain photographs and news articles and analyzes those documents. And the objective evidence is quoted at paragraph 45, which is at page 55 of the bundle. This is where the judge quoted from the CPIN that I've just taken you to.
Yes.
Of course, not all relevant parts are quoted, but the judge proceeded on the basis that that was the objective evidence. You then have the three offending paragraphs. Ground 1 concerns paragraph 46. Ground 2 actually concerns that paragraph too. You'll see that the judge made a finding that MU's evidence that he was politically active in Bangladesh, attended some events in the United Kingdom, and was attacked on the occasion of his visit in 2019 was credible. I do not seek to challenge that finding. That finding stands. My submission is that the judge has made no decision as to MU's profile. There is no finding in that paragraph that MU was a high-level member of BNP. Submission is that the judge proceeded on the basis that being politically active in Bangladesh is sufficient as long as there are some attendances in events in the United Kingdom and one attack by non-state actors. This is not, in my respectful submission, what the objective evidence stated.
Right, so a bare finding of political activity in Bangladesh, which was a country that he didn't leave because of political persecution, but in order to come and settle here, you say could not, as a matter of law, establish the conclusion that appears at 49.
Yes, so the finding was not open to the judge on the objective evidence. And the linked submission is that the judge was obliged to form a view as to, use that word again respectfully, as to the profile of MU. But what that actually means.
Hang on. You seem to be rolling up two different kinds of legal challenge there. A submission that a finding that he was or would be at real risk of serious harm if returned to Bangladesh was not open to the judge on the objective evidence is, although not everyone likes this label, effectively a perversity challenge. You're saying that it wasn't open on the evidence. A finding that she failed to make a crucial finding as to the degree of his political involvement
Yes.
is an error of reasoning
Yes.
amounting to an error of law and would, in principle, and subject to any other submission you trailed earlier, result in a remission for them to decide to decide that crucial fact.
Yes.
Which is your position?
Both. So I
Yes.
have made both points in my skeleton argument. There's one further point, but my lord is absolutely right that these are two distinct points. I've made one point at paragraph 19 of my skeleton, which is that there is no finding by the FTT that MU was a high-level member of BNP. And the second submission is one that I've made at paragraph 20, which is essentially a perversity challenge, that it was not open to the judge. I emphasize challenging the findings made at 46, but I'm submitting that it was not open to the judge to find, on the basis of those findings, on the objective evidence, that there is a risk of ill treatment contrary to Article 3.
It's unusual to see a perversity challenge in circumstances where we don't have the totality of the evidence. It's true we have the CPIN. True we have at least a summary of his witness statement and oral evidence. But you say we can nevertheless make a perversity finding on the facts in the circumstances of this case,
Yes.
but it's within a fairly narrow scope.
Yes. Lord, the reason is that I'm not challenging the finding at paragraph 46 per se. The
No.
submission is that finding could not, on any legitimate view, lead to the conclusion that there was a risk of treatment contrary to Article 3. And therefore, whether you accept or reject this submission does not depend on the evidence that MU had used, but on the objective evidence that I've taken you to, the objective country evidence. So finding that a person is politically active in Bangladesh, or was politically active in Bangladesh in 2016, was no longer a member of BNP,
Yeah.
is on the objective evidence not at risk
Well,
because of the political activity.
it's important, perhaps you're going to come to this, but just to flag it up now, it's important also in this context to distinguish between at risk from the state,
Yes,
of which,
that's the third point.
speaking for myself, I see very little evidence here. The only incident was clearly non-state actors, and risk from non-state actors.
Yes.
Yes.
So, Lord, you have my 2 points. First, failure to decide the level of involvement in the politics. Second, that the ultimate conclusion was not open to this evidence. My third point, my lord, is about the point that you have just made. And may I just skip over the remaining part of paragraph 46 and 47? I'll come back to
That's
that paragraph
relevant to ground
because
two,
that
yeah.
concerns ground 2, and ask you to look at paragraph 48. So assume, my lords, that I'm wrong about the first 2 points, and that
Sorry, just before you plunge into this one, this all started, as Mr. Collins, I think, points out, as a reasons challenge. And that's very much how it was put, I think, on the appeal from the FTT to the UT. And there's an element of it still in the appeal, in the application to the UT for permission to come here, but it then drifted away. Is there a reasons element to your challenge?
No, Lord, I'll show you the Upper Tribunal's decision.
Yes, very well.
The 3 points that I'm making are not new points. Those points were made by the Secretary of State at the Upper Tribunal.
Yes, I wasn't so much suggesting these points weren't open to you. I'm see
Yes.
that Mr. Cronin says that, but more whether they could also be characterised as a reasons challenge. It's a rather blurred area.
Yes, yes. Lord, although, of course, it's quite tempting to say that there is, but I think it would be unfair on MU for me to say that there's also a reasons challenge which
Okay, no, that's fine.
Is not pleaded.
Okay. No. Right. Sorry. Going back to the to what you were about to say by reference to paragraph 49.
Paragraph 48, my lord.
48. Sorry. Yes.
Yes. Assuming that I'm wrong about the first 2 points.
Yes.
And that there was a risk. The judge then says at paragraph 48 that MU is well known in his home area where he was attacked. You'll hear from a learned friend, but my submission is that there is no proper evidential basis for that finding. But the problem, the key problem with this passage.
Yeah, I mean that's only a secondary point in a sense. It's not. It's not the point you're about to make. It's not really a very damaging finding anyway.
No. So the judge says that he will come to the attention of Awami League members and supporters. On the basis of his previous activities, and when asked any questions about his background and activities whilst in the United Kingdom, about which he cannot be expected to lie, be this on arrival at airport or once he has left the airport. In my perspective, submission, this is a bad point. I mean, this isn't a case where MU would be stopped at airport and would be asked about his political affiliation. We are not in that territory at all.
And certainly it's not. There's no evidence that on the 2 occasions he came in, he was asked.
Yes,
No.
yes. We are not in that territory. And we are certainly not in that territory where Awami League supporters would stop him and ask him about his political affiliations and he wouldn't be expected to lie. We are not, in my perspective, submission, in that territory at all. But then, again, skipping the next 2 sentences as they relate to the second ground, the final sentence of paragraph 48 is that sufficiency of protection and internal relocation are therefore not options available to him. That, in my respective submission, is wrong in law. Although AL was in power at the time, this isn't a case where the issues of sufficiency of protection and internal relocation did not arise at all. The reason being that the risk is not from the state, but at the hands of non-state actors.
Well, hang on. I take your point entirely as it goes to internal relocation, but sufficiency of protection is often a key question where it's non-state actors.
Yes.
You can have a situation where the state isn't going to persecute you.
Yes.
But if you turn up at the police station and say, I'm a BNP supporter and I was attacked by some Awami League supporters, they'll say, get lost. Yep. And speak for myself, that finding is probably a common sense finding open to the judge, isn't it? The better point about internal relocation.
Yes, Lord, that Lord was the reason why I showed you the part of CPIN that concerns sufficiency of protection. It makes 2 points. The first is that if the risk is from the state, if an applicant says that the authorities are going to target him, then that means that you cannot. Then that's the end of the
point. Can't go to the authorities for protection, obviously.
But
when
the risk is from non-state actors, CPIN tells us that the decision makers are then required to make an assessment.
Yes, I see. Okay.
Taking into account, I know. My Lord Justice Peter Jackson is not impressed with the word profile. Taking into account, as CPIN says, profile of the person.
Yes.
The judge was required to, in my respective submission, consider the issue properly and decide whether there would be sufficiency of protection. We know from the evidence that when MU was attacked previously, he did not report the matter to police. It would have been open to him to make an argument. It would have been open to the judge to explain that, essentially make the point, my Lord, that you have made, that if MU had approached the police station, the answer that he would have received was that we are not going to protect you, but the judge hasn't made that assessment.
Yes, I see.
The same applies to the question of internal relocation. If he's at risk from non-state actors in Sylhet, it's open to him to go to Dhaka or to another place where no one would know who this person is. And there's no finding that the non-state actors were so influential and powerful in Bangladesh that they would have means to find out that he has returned and relocated to another place. We are not in that territory. But the judge, in my submission, made a plain and obvious error in that paragraph in proceeding on the basis that the question of internal relocation and sufficiency of protection does not arise at all. So these are the three reasons why, in my respective submission, the judge erred on ground one.
Thank you.
The second ground concerns a finding that appears in the middle of paragraph 46 and towards the end of paragraph 48. If you look at page 56...
Sorry, if you succeed only on the third ground, that again, that is only that requires a remission. We couldn't decide that, obviously. It's not. No, I put it badly. That is. Well, it would only require a remission. It wouldn't. You couldn't put a perversity label on that. That's what I'm trying to say.
That is right. But the question that my lords will consider, subject to any submissions that my learned friend makes, is whether there is now a prospect of a different outcome.
Yes, I'm parking that point. Yeah. But I'm just pretending for this purpose, as an intellectual exercise, a necessary intellectual exercise. There hasn't been a change of regime.
Yes.
And we would then be saying,
absolutely,
you should have dealt with sufficiency of protection and internal relocation. They didn't follow from your previous findings.
Yes.
Therefore, we must go back and deal with them.
Absolutely, that's the middle.
And we might have a private view that they were quite strong or quite weak, but it's a matter for the fact-finding tribunal.
Yes.
Yeah. Okay. Thank you.
Yes, I'm not sure if Lord Lodis has been had a question.
No, I'm just focusing on the last sentence of 48 and the conclusion of 49 are actually the two sentences you object to.
Yes.
And one could say of the last sentence, 48, that it's a perversity challenge or it's a reasons challenge. It seem to me to be different ways of describing the same thing. You simply say, as regards sufficiency of protection, and certainly as regards internal relocation, you say, therefore, doesn't cut it. Even if everything in the judgment before that sentence was accepted as correct, you say, but say what? You haven't explained why internal relocation is not an option available.
Yes.
You haven't really explained why there's insufficiency of protection afforded by the state.
Yes, the essential complaint, it seems to me, is a crucial absence of reasoning, which is what you would need in order to establish an error of law.
Yes.
But your further point, which you yet to fully develop, is that there would be no need for this court to remit because there was no evidence upon which the lack of reasoning could have been cured. It wasn't just that there was a missing amount of reasoning, but even if the reasoning had then been conducted, there was no evidence upon which it could have operated to show that you bridged the gap, as my lord puts it, that it cut it.
Yes. Just, my lord, in fairness to MU, if there hadn't been a change in country situation, and if I was only making the third point, perhaps it would have been a little difficult for me to then say that there is no point in remitting the appeal because the outcome is inevitable. Because case law tells us that the question as to whether internal relocation is a viable option is a fact-sensitive question. I have to look at the range of.
Yes, I don't want to make you take a point you don't want to take or feel you professionally can't, but just so we can think it through, it is the case that the burden, well, I don't know. If you show you are at risk of persecution in one area, is there a legal or evidential burden on you also to show that you wouldn't be at risk anywhere else in the country? Or does at least the evidential burden shift to the Secretary of State to say, all right, well, even if you're right about that, you can move to Dhaka? I don't know. Is there law about that?
Yeah, there is.
Which does it say? What does it say?
Yeah. So, I mean, there is a line of authority as to whether it is appropriate to describe the point as in terms of burden of proof.
Yes.
So it's more akin of an assessment that the Supreme Court.
I see. It's one of those fuzzy things that says burden of proof is the wrong concept.
Yes. So it's
Right.
actually an assessment that the First Tier Tribunal is required to make. So it isn't appropriate to proceed on the basis that X has the burden of proof or the Y has the burden of proof.
Okay.
SC Jamaica is the last word on the subject from the Supreme Court.
So,
But here you don't yes.
You go ahead.
Yes, but here the short point is that the judge hasn't made any assessment at all. Proceeded on the basis that if someone is politically active in Bangladesh, that's the end of the matter. That person is at risk wherever it goes, and that is a flawed finding. So just for the purpose of your note, the 3 points that I've developed orally are at paragraphs 19, 20, and 21 of my skeleton argument.
Yes, thank you.
Need a page reference is page 12 of the bundle, where you have those 3 paragraphs.
Yeah.
So that is ground 1. Ground 2, if you look at page 56 of the bundle, line 3, the judge makes a finding that his answers at the interview would have been affected by his mental health presentation at the time he claimed, including dates. In my respective submission, there was no evidential basis for that finding. I've shown you earlier in the decision where the judge summarizes the expert evidence. The unchallenged expert evidence is that MU has major depressive disorder. So it's one thing to say that a person has major depressive disorder. It's quite another to say that his evidence in the interviews is affected by it. So the evidence that is summarized at paragraph 37 does not justify the finding that you have at paragraph 46. Then look at paragraph 48. Line 8, the judge says that MU's mental health symptoms will also attract further...
Just before we leave that, yes, we do need to take into account the judge's paragraphs 35 and 36, where he sets out quite a lot of background evidence about how his mental ill health was affecting him.
Yes.
And although that's not the same as a doctor giving an opinion that his depression would be likely to have affected his ability to answer effectively an interview, is a judge not entitled to take a common sense view about, once satisfied he really was suffering from depression and having some contemporary statements about how it was affecting him, reach the conclusion that he did in para 46?
Yes. Lord, if you look at paragraph 35, the judge says that MU explained in the oral evidence that he had wanted to answer all questions put to him at the substantive interview truthfully, but had mental health issues and suffered from COVID.
Yes, right. Well, that's right.
Now, this is what he said, and then paragraph 36, MU also said that he was tired, weak, and depressed. And he also said, when he was asked about the party's flag, that I would be able to tell you in due course when I am out of the prison.
But that's it was up to the judge whether she believed him, but that's a kind of description of his mental state backed by a mental diagnosis that would entitle her to say he was in a bad way at the time of his interview, and it's not surprising he didn't answer questions you'd normally expect him to be able to answer. You don't have to be a doctor to give formal evidence to that effect, do you?
Lord, yes, but that's not how, in my submission, the judge puts the point at paragraph 46. The judge says that I find that the answers would have been affected by his mental health presentations. Now, if the expert had said that this person has major depressive disorder, and he had major depressive disorder when the interview was conducted.
Well, we don't know. He didn't say that, so we haven't seen the report.
No, you have a summary of the evidence at paragraph 37. And if the expert had then said that, well, the inconsistencies in the interview or the gaps could have been caused by the depressive disorder, position would have been different.
What was the date of the interview?
2nd of August 2022.
Yes, I see. So Dr. Kashmiri's report was about over a year later. Yep.
Yes.
Okay.
Speaking for myself, it's difficult to see to what issue this goes. It may explain, the judge is entitled to find that it explains, for example, his inability to describe the party flag, but it only goes to a limited extent to any finding about his political status, let's call it, or level of seniority or activity within the BNP, and I don't see at all how it could go to sufficiency of protection or internal relocation.
No. So this is an alternative ground to ground one. If you reject ground one, and if you take the view that the judge has entirely properly looked at all the circumstances and formed a view as to MU's profile, or looked at all the characteristics of his person and political activities, then the second ground is that the judge erred in holding that the discrepancies and gaps in the interview were caused by mental health problems. So in other words, the judge erred in forming a view as to MU's political profile.
It's a bit of a stretch to say that's an error of law, isn't it? I mean, realistically, this is about ground one, isn't it? You don't get home on ground one. Ground two is peripheral, isn't it?
Lord, you have my submission, but can I just make one further point that may and make one further attempt to change my lord's view, and that is what the judge says at paragraph 48. Line 8, where the judge says that MU's mental health symptoms will also attract further attention.
Well, you can say, from whom? Huh?
Yes, so this is where the judge is considering, he's saying that MU would be at risk because of his mental health symptoms.
You say, by the way, the judge is a she, isn't it? I noticed that.
My apologies. Yes.
No, it doesn't matter at all. It's just the Upper Tribunal also misgendered her. I just wanted to make sure I was right.
Yeah. Yes. So no engagement at paragraph 48 with the level of attention that MU would receive or ways to address his symptoms.
Yeah. Well, the Upper Tribunal is basically with you on this point, but said it doesn't affect the underlying reasoning.
Yes. Yeah. So, of course, as I said, this is the alternative ground that the court would need to deal with only if I fail on ground one. Now, the question before the court is whether the First Tier Tribunal erred on a point of law. Therefore, what the Upper Tribunal has said is of no consequence. But can I just very quickly show you the Upper Tribunal's decision?
Yes.
Page 33 of the bundle. The panel summarizes the two grounds at paragraph 3.
Yeah.
And if you look at the middle of that paragraph, you'll see that the fundamental point was that
I'm not sure this goes anywhere, but in fact, it looks as though the mental health point was taken first.
Yes.
And looked as if it was the one that the senior Home Office presenting officer majored on. But you, if I may say so wisely, have put them the other way around.
Yes. Surely the second ground as it was pursued is a better ground. But the point that is made in ground 2 is summarized in the middle of that paragraph that concerns the appellant's MU's contention that his mental health condition had affected his ability to recall parts of his own account of past events. Now, this is the fundamental point that is made as the first ground before the Upper Tribunal. Paragraphs 5, 6, and 7 are paragraphs where the Upper Tribunal deals with that ground, and that point is not answered. So paragraph 5 is a complaint that the Secretary of State made that MU should have produced GP records as well. I do not make that point in this appeal. So I'm not pursuing that point.
Yeah.
Then paragraph 6, the judge says that the presenting officer agreed with the diagnosis of major depressive disorder. I accept that is the case. I'm not seeking to go beyond that concession. And then paragraph 7, the panel notes that the dispute before the tribunal, before the first judge, was about the cause of mental health problems. I do not pursue that point either.
Yeah, it does, and doesn't. I don't see why it ever mattered what the cause was. Either he was depressed or he wasn't.
Yes.
Anyway, so you basically say you accept all three of those points, but they don't meet the point that the presenting officer was making.
Yes.
Yeah.
And then paragraph 9, where the judge deals with ground 2, which is ground 1 on the appeal. I submit that the panel was wrong in finding that there is no error of law by the first judge. So for these reasons, my lords, I invite you to find that there is an error of law in the First Tier Tribunal's decision. Invite you to set aside the decisions of the Upper Tribunal and the First Tier Tribunal. You'll hear from a learned friend shortly, but unless he persuades you otherwise, I invite you to substitute a decision dismissing the appeal because there is now no conceivable way on which MU can succeed on Article 3 grounds.
Well, okay, that's an important submission from your point of view, and maybe there's nothing more to say about it than you have just said. But you simply say it's clear from the up-to-date CPIN that the only risk on which he was relying, namely persecution from Awami League supporters, is no longer a risk, and it's a waste of our time to send it back.
Yes.
That effectively means us making a finding of fact for the first time in this court on the basis of fresh evidence. Not how such an application is normally made.
Yes.
Let me just be clear about this. So I'm just thinking it through. You are hooking it on the fact that we, ex hypothesi, we'll have found an error of law. So it's really a question of what we do. Just so we can get this out of the way, you are not advancing it, and you couldn't advance it as a freestanding ground of appeal, that things have changed in Bangladesh. You're introducing it, I don't mean this in any way pejoratively, but by the back door, or on the back of the fact that a completely different error has been made. And then you're saying, well, why waste everyone's time going back for a different decision?
Yes.
Sorry, going back for a decision to which there's obviously only one answer, but on the basis of fresh evidence.
Yes. So, my lords, your jurisdiction is, yes.
Yeah.
Lord, so the jurisdictional basis is Section 14 of the Tribunals, Courts and Enforcement Act 2007.
Remind me what that says.
Yeah, and subsection 1 says that the first question for you, my lords, is whether there is an error of law in the decisions made below. Subsection 2 says that if you find that there is an error of law, then you may, but need not to set aside the decision of the Upper Tribunal. That does not apply here. So subsection 2b says that if it does, if you set aside the decision, you must either, Roman 1, remit the case to the First Tier Tribunal or the Upper Tribunal. Roman 2, remake the decision.
I see.
And then, so subsection 3 then says subsection 4 says that enacting under subsection 2b2, where you're remaking the decision, you're entitled to make any decision that the tribunals below could have made. And you may also make such findings of fact as you consider appropriate. So I'm inviting you to make a decision on the basis of the findings of fact that the judge has made. Simply inviting you to say that on those findings, there is no prospect of a different outcome, or you simply decide.
Well, no, sorry, that's effectively your perversity case. But on the fact that everything has changed in Bangladesh,
yes,
that's not based on any finding the judge has made. That's based on new evidence introduced for the first time in this court. But you say that's open to us under 2b2.
You preserve the previous findings and you add the new information about the situation. Your position would presumably be that, given the major change in the country of origin, no question about internal relocation arises any longer. No. One could see that if it was in a greyer area where there might be a question of internal relocation, it would be very unfair to a person to make a finding of fact without giving the opportunity to file evidence.
So we're not in that territory.
It may be simply because this is an unusual situation. I can't myself think of any case in which this court has remade the decision on the basis of subsequent developments. But you say, why not? Provided they are,
Yes.
I mean, you may be able to refer us to some case where it has happened, but I haven't.
I mean, there are examples where the court has sort of substituted a new decision, allowing the appeal, saying that the first tier tribunal erred, the upper tribunal erred, but the outcome is so obviously clear that the appeal should succeed. The appellant is a refugee because of, on the objective evidence, the appellant is a refugee.
Yes, but that will be where where you say that the judge made an obviously wrong decision on the evidence that was already available.
Yes.
And that's classic. I mean, no problem with that. What's unusual about this is evidence which has emerged for the first time in this court.
Yes.
Without, and I'm not necessarily saying this is necessary, but without any application to adduce fresh evidence or anything like that, you would say this is CPIN speaks for itself.
Yes.
Well, let's hear what Mr. Collins has to say about it.
Yes.
Can I just ask one supplemental question? Sorry, I beg your pardon.
If we were with you on setting aside the decisions below, but against you on making the decision ourselves, is the appropriate remission to the FTT or to the UT?
Well, it would be first tier tribunal, because you are setting aside the decision of the first tier tribunal as well. But it makes
both, aren't we?
Yeah, it makes no practical difference to the Secretary of State, but
It made some practical difference because, at least in theory, if he's remitted it to the FTT, they would have a route of appeal. Now,
Yes.
if it's as open and shut as you say, they wouldn't get permission.
Yes.
There's something to be said in terms of economy in simply remitting it to the Upper Tribunal.
I have no particular
Okay.
preference.
Right.
I mean, whether it goes to perhaps this court's jurisdiction is somewhat similar to the Upper Tribunal's
Yes,
jurisdiction,
quite.
because Section 12 deals with appeals from the First Tier Tribunal to the Upper Tribunal, and Section 14 deals with the appeals from the Upper Tribunal to this court. And the language of both two provisions is identical. The Upper
Yes.
Tribunal performs the same function. It can also sort of remake the decision on fresh evidence. So if I was arguing this appeal at the Upper Tribunal, and if I had made the 4 points that I've made before the Upper Tribunal, and there was now change in the country situation, would have been making the same point that the Upper Tribunal should set aside the First Tier Tribunal's decision and substitute a fresh decision dismissing the underlying appeal. So whether it goes to the Upper Tribunal or the First Tier Tribunal makes no practical difference. But I do submit, of course, you'll hear from a learned friend, but AL is no longer in power. So
No, I know we get the point. We're saying if we're against you on that, who does it go back to? But your primary position is anyone can remake the decision.
yes,
The Upper Tribunal could, but we can, and why waste time?
yes.
Well, let's hear from Mr. Collins.
Very good.
Right.
Yes, Mr. Collins.
Well, you said in passing, Mr. Malik's nearly always right.
So sorry, I just didn't hear. Yeah.
We say this is an occasion, perhaps a rare one, where he's wrong. And that
I didn't mean he was right, always right in his submissions. I only meant if you asked him for a reference to a case or something, he's generally gets it right.
I appreciate that, my lord. But in essence, our case is that this is mere disagreement, not just with the FTT judge's findings, but also the approach and concessions on the part of the HOPO at the FTT hearing. It's clear
that the author of the grounds to the UT was unimpressed with the Hoppo's concessions and his approach, but we say that it is not an error of law. Just to go through my notes, the order Mr. Malik made his submission, you were given a very brief overview of the respondents' political activities in Bangladesh. Fuller detail you'll find in my skeleton.
Yes, that's very helpful. That's comprehensive, gives all the references.
I'm grateful for that. As to the second point I've noted is, if there's an error of law found, where does this go? And the simplest, so in essence, Mr. Malik's saying, any appeal is bound to fail. Now, even, we say, if I needed to argue it, I'd say the situation in Bangladesh is still fairly volatile. We've not put evidence into that effect for obvious reasons. But the simplest way of showing that an appeal would not be bound to fail is to go to the most recent CPIN, tab 2, and you'll see halfway down, page 75, leaders, members and supporters of the BNP and their auxiliary student youth organisations are unlikely to face persecution or serious harm.
So sorry, 70.
Page 75.
Yes. Which para?
Halfway down, second one, beginning leaders, members and supporters. So the obvious point there, that it's not about whether it's likely or not, it's whether it's reasonably likely, of course. And more importantly, perhaps, the final sentence on that page, where a claim is refused, it is unlikely to be certifiable as clearly unfounded. So even the respondent in this CPIN does not suggest that a claim by a BNP party member activist is bound to fail.
I'm sorry, where was the last
It's the
passage?
final paragraph, my lord, page 75. That where a claim is refused, it's unlikely to be certifiable as clearly unfounded. And you will know that a certification on such a basis means could not on any legitimate view succeed. So the respondent, sorry, the Secretary of State does not suggest in the most recent CP that a BNP claim, for want of a better description, is bound to fail.
Well, I mean, there's nothing here to suggest although it's probably in here somewhere, whether the BNP is now in power or merely not being persecuted. But there's nothing here to suggest that there's any risk to BNP members. Such risk as there is likely to be to Awami League members, isn't it?
Certainly that would appear to be the case, that some Awami League members, particularly high profile, would be at risk. But I just fasten upon the final sentence. I do not read this CPIN as suggesting that BNP members, activists, so on and so forth, are bound to fail. I've read it twice and I don't see any suggestion in this CPIN that such a claim is certifiable.
But realistically, the time that this CPIN was issued, the kinds of people who would be saying, I can't be sent back to Bangladesh because I will be persecuted for my political opinions, are going to be Awami League supporters. That's surely what the Secretary of State, or not really the Secretary of State, but the authors of the information note had in mind when they made the point at the end of page 75.
That's why, my lord, I took you first of all to the second paragraph beginning leaders members of the BNP on the same page.
It doesn't say the BNP, it says leaders of political groups, it says.
Leaders, members and support.
Oh, I'm so sorry, yes. Yes.
And I stress the unlikely.
Yes.
And you have the point. I
Yes,
sought
all
to
right.
make at least.
Okay.
Yeah.
Thank you.
Thank you. Third point as to, in your words, my lord, what tools are available. There clearly are tools available. Mr. Malik has agreed with that in terms of even if the respondent had have been granted restricted leave, which is the probability in a case such as this, given his offending, that can be taken away. So that's not an issue which we suggest should concern this court. It's open to the respondent if she really believes the situation has changed on the ground to the extent that NU would not be at risk to come to, well, if not come to a further decision, not to grant him any leave to remain in the United Kingdom and to take enforcement action.
Can you just elaborate on that, because I'm ignorant in these matters. If the appeal to this court were dismissed, but the Home Office took the view that it was undesirable that your client should remain here, what steps could they take in practice?
In practice, in my experience, restricted leave would be given to a person such as the respondent.
Restricted to what?
Not so long ago, it used to be a rolling period of 6 months, and there were challenges in this court and elsewhere to the rolling periods. But generally, for want of a better description.
Yeah, but just take it in stages. Suppose the appeal were dismissed, so it had been established by the FTC that he had that his deportation would be a breach of his human rights. He would then have to be given a form of leave, and as you rightly say, that would be what used to be called restricted leave. I think it is still called restricted leave, and as you say, it's a lot less good than ordinary leave to remain. There are all sorts of inhibitions, and it's generally for a short period, at least at first. One of the reasons why it's on a short period is that things may change in the country to which you cannot be returned, in which case you can be returned. So suppose the Secretary of State gave 6 month restricted leave and then refused to renew it because they said you were a foreign criminal and there was no longer any risk, then that would be open to her to do that, and that would have to be challenged.
Yes. It would also be open to her, in the circumstances of this case, not to grant any leave.
Well, that's really what I was coming to. You say, in fact, because there has been a change of circumstance, she could in perfect good faith say, I respect the decision of the court which related to the historic position, but in the meantime the position has changed, so I'm going to continue to deport, and there would have to be a fresh, she'd have to make a fresh decision to deport because that decision's been challenged, but it has been quashed, but she would make a fresh one, which wouldn't, on the face of it, be abusive because the circumstances had changed. And you say subject to any possible challenge, she could then remove him.
That's how I see the situation, yes.
Yeah.
And that would continue for a period of months or possibly longer during a time when he's considered to be of risk to women and of high risk to some women.
Yes, he's not here today. He's subject to electronic monitoring. He's not in immigration.
Presumably he's been released from prison simply because he served half his term.
Yes.
Is the electronic monitoring in support of immigration bail, or is it peculiar to his? Is it a condition of his leave?
My
Condition of his release.
It's a condition of his release.
Yes. And that will continue until he's been out for 6 years.
You may see reference in the papers, as also is a condition that he can't reside in the area where his victim
Yes.
lives.
Well, I mean, on a purist view, which I think we are obliged to take, in the sense we explored this slightly with Mr. Malik because he mentioned it himself. But as Lady Justice Andrews pointed out, these points are really not relevant to our decision.
No, and I say with all respect, they shouldn't have featured in the grounds or the skeleton argument.
Well, we are where we are, but we're well aware of what our formal approach must be.
Yeah.
Yep.
Thank you.
Very well.
So
Where do we go next?
You were taken to the 2020 CPIN.
Yes.
2.4.7, at which the judge refers to in some detail. Could I also take the court to 2.4.5, so tab 1, page 8 authorities bundle. In terms of, I got back to that word profile, but one does not need, or did not need then, a particularly high profile to be at risk. And you'll see there, BNP and JI officials claimed mass arrests and detentions of their supporters, with thousands facing trumped up charges. And then halfway down, perhaps beginning, there are reports of police extortion whereby numerous arrested activists and leaders, not just leaders, are routinely released on condition of payment, reports of torture in police custody.
But he has been back twice. On neither occasion has he been the subject of any adverse attention from the authorities. Well, this is a non-state actor case, isn't it?
Technically speaking, that must be correct. But given the nature of Bangladeshi politics at that time, it comes from the state. That's what I would suggest. And you'll see, I was just about to move on, my lord, to
Yes.
2.4.16. Same CPIN, page 10. Decision makers must consider whether there are particular factors specific to the person which would place them at real risk. Each case obviously must be considered on its facts. And the particular factor here is Ilyas Ali. You'll see reference to him in the FTT decision and the UT decision. And it will not be an issue that Ilyas Ali was a very high profile BNP leader who disappeared, presumed kidnapped, some presumed dead. And the appellant, the respondent's case throughout has been that he was particularly close to Ilyas Ali. And you will see the finding in the FTT decision, in fact the acceptance again by the HOPO, that there was photographic evidence of the appellant together with Ilyas Ali's wife.
But what did the FTT judge conclude from that?
I suggest, my lord, that when she pulled all of this together, she implicitly at least, and perhaps one could say explicitly, found that the respondent was in fact a person with a high profile within the party in Bangladesh. As she says, very well known in the home area, had been involved with Ilyas Ali, but also Mr. Malik didn't take you to some political activities in the United Kingdom. I've set them all out, as I say, at paragraph 6 of the...
Let's just have a look at your skeleton. mention of Ilyas Ali is at 10, the last of your helpful bullet points, and 2. He was in the group of Ilyas Ali.
Yes.
And that you refer to paragraph 28 of the FTT decision. Let's just see exactly what it says about that.
Those are his submissions.
Yes.
But where are the findings based on this? Speaking for myself, the politicians the world over, including the UK and Bangladesh and many other places, have their photos taken next to people. But that on its own is not a basis for finding that the person who's photographed next to the Prime Minister or the leader of the opposition or whoever it may be is a high-level political activist.
In this case, what the appellant was in effect saying is, I attended.
But let me just be clear what he was saying. He was saying he was in the group. I've no idea what that means.
Paragraph 33 of the FTT decision, perhaps.
Well, that doesn't say anything about Ilyas Ali as such.
Well, it says, I was deeply involved in politics.
Yes.
And then we move to 34. In oral evidence, he stated he did not accept he had a small role in BNP. He was active within his group.
Yes, I see. That's the key paragraph, in fact, as far as his evidence is concerned.
And we say that all of that evidence was accepted by the FTT judge.
Would you mind looking at 39(1)G, which is the photographs? Page 33, where there was a photograph, including your client. Is that the one photograph with, it was one photograph with
There was one photograph in particular of the appellant, the respondent's evidence was to the effect of my instructions were that this was me with Ilyas Ali's wife.
Yes.
And the reason you'll see reference in the FTT decision to a further 2 photographs being submitted during the lunch adjournment were photographs of Ilyas Ali with his wife, and the HOPO accepted that Ilyas Ali's wife in those photographs was the same person.
Yes.
Yeah.
But I mean, I just following up on my Lord of Justice Bean's question, the actual evidence of a direct link with Ilyas Ali's wife was particularly related to this photograph at page 33 of the bundle that was before the judge.
And his oral evidence, my lord, as well. Yes. And written evidence. Yes.
Ilyas Ali disappeared in 2012. At which point, what age was
He'd have been about 23.
Yes.
But his case was that the disappearance of Ilyas Ali, not just high profile, was extremely contentious.
Yes, no, I see that.
And of course, not just I'm from the same party as Ilyas Ali, I'm from Ilyas Ali's group. Ilyas Ali used to delegate me.
Yes, para 34 is the high watermark of your case about his evidence on Ilyas Ali.
Yes.
Yes, thank you.
Thank you. My lord, the next point, it relates to sufficiency of protection in internal relocation.
Yes.
And if I could ask you to go to paragraph 7, the FTT decision, page 48. And you'll see, we've been there already, Roman 1 to Roman 4, and the judge making clear that, well, I say it's clear, that she discussed with the representatives, me in that case for the, as he then was appellant, and the Hoppo, were we effective to proceed? Yes, and the issues in the appeal, and the agreed issues are Roman 1 to Roman 4.
So sorry, I thought I had the right reference, but I don't. Which paragraph are we on?
Paragraph 7.
Yeah, sorry. Yep.
And I suggest that because notwithstanding what's in the decision letter, the Home Office presenting officer took the view that if the FTT judge found in favour of the, as he then was appellant on the facts of the case, there would be no sufficiency of protection or an internal relocation option, and he did not argue anything contrary to that. There's nothing certainly like.
Well, 7.3 is completely neutral on that, because to succeed under Article, the questions of sufficiency of protection and internal relocation are part of the Article 3 issue. So the fact that you agreed those were the issues certainly wouldn't exclude internal relocation. So what you're really saying is that, are you saying that Mr. McRae, is that what he's called?
Yes.
Mr. McRae conceded those points? It's a bit surprising if that was so, because it's a theme thereafter, that not just raised by Mr. Malik, but from the first appeal onwards, saying you didn't deal properly with internal relocation. Am I not right in that?
Oh, yeah, yes, in essence, the agreed issues were as set down by the judge at paragraph 7.
But that's fine. That includes internal relocation and sufficiency of protection, doesn't it?
Perhaps the Hoppo and the judge.
Sorry, I'm getting a bit deaf. Let's speak up.
The judge, I believe, and it's clear from the decision, accepted our case, which was to the effect that if the factual matrix of the appellant's claim was accepted, there would not be a sufficiency of protection, and certainly there would not be an internal relocation option, because...
Well, you say that was, may well have been your case, I imagine it was, but to say the judge accepted that necessarily followed doesn't mean she was right to do so.
No, I accept.
Yeah, I just don't want there to be any misunderstanding here. At one point I thought you were saying, but you hadn't, I'm afraid, demonstrated, that Mr. McRae had positively conceded that once risk was shown, sufficiently serious risk was shown, there weren't any separate issues about internal relocation or sufficiency of protection. And I certainly don't see any such concession recorded here.
I don't go that far, my lord.
Yes, I see. Okay, thank you.
As to what's now ground 2, I respectfully agree with Lord Justice Peter Jackson's observation. It seems to me that's somewhat peripheral to the real issue here. But in any event, we say that the judge did adopt a common sense approach, it being accepted that the respondent suffered from mental health issues, that would have affected the answers he gave during the course of an asylum interview, particularly when he'd just come out of isolation, having suffered COVID. There's nothing untoward about any of that, the approach or the findings. Next note, my lord, I don't know if you want it. It's a case Mr. Malik was involved in. The point you made about or raised about internal relocation.
Yes.
It's a decision of this court. Is the most recent, I believe. But it's not post-dates the Supreme Court. ASJ Somalia. Yeah, Mr. Malik's nodding in agreement. I'll give you the citation if you want it. 2025.
Is this in our bundle?
No.
No. What's the proposition that you're?
No, it's just you raised internal relocation with Mr. Malik.
Could you just finish the reference?
ASJ Somalia.
Yes.
2025. EWCA Civ 282.
Well, it is. I mean, I didn't raise any question about internal relocation with Mr. Malik. Mr. Malik, part of Mr. Malik's case is that the way the judge deals with internal relocation is inadequate.
I'm sorry. Then, if it's not helpful.
Well, no. Well, I don't know it's helpful until you tell me what the point is. So I'm not trying to.
It's just because there was a discussion about internal relocation, and that, notwithstanding Mr. Malik was involved in that case, he's involved in many cases. We know. It was just to give you. It's a very recent case.
Oh, okay. Well, that's very helpful. If we need to remind ourselves.
What does it say?
Mr. Malik's probably best placed to tell you that, my lord. But it seems to me it says there's no burden on the respondent. Yeah, I'm getting.
I see. I'm sorry. It's that point.
Yes.
Thank you. Right. It's the point about you shouldn't look at it in terms of burden. You do an overall assessment. Yeah. Okay. No. Well, now I see what you say. That's helpful. Thank you.
And then, really, my lord, it's just our skeleton. I do rely on the rest of the skeleton argument. I won't take time, unless you want me to, with particular features of that. But in essence, our case is that this is a mere disagreement with the FTT judge's findings.
If we were to find that there was an error of law in the FTT's approach, but that on the factual situation as it was in 2023-24, there wasn't only one right answer, so it's not a perversity case, then typically we would remit. We would have to remit, either to the FTT or the UT in its fact-finding function. Two questions. One, do you have any submissions about whether it should be to the FTT or to the UT? Secondly, and more substantially, what do you say about Mr. Malik's submission that we needn't remit at all, that we have jurisdiction under the TCEA, Section 14, whatever it was, 2B2, effectively to remake that jurisdiction we're very familiar with in the Upper Tribunal, but which he points out we also enjoy. And if we do that, we can remake on the facts as they now are. Now, you've explained at the very start of your submission,
Yes.
what your submission about the facts are, but do you accept that's open to us?
Of course, it's open
Yeah.
to you. As to the first of your questions,
Yes.
my lord, given the nature of this challenge, I suggest the normal course of action would be remittal to the FTT.
Yeah.
A reasons challenge of an FTT judge. And as to the second question, you have our answer. That we've not put our case taken at its highest. If all the factual findings haven't actually been impugned. We say again, this man, whatever the unsavoury nature of what he's done in criminal activities, it was a fairly high-profile activist in Bangladesh. He should be allowed the opportunity to make submissions, put evidence in, as to for him to show that he would still be at risk.
Yes.
I say the situation is still volatile there. That much can be gleaned even from the CPIN, I think. But certainly, as I say again, the CPIN does not suggest that such claims are certifiable as clearly unfounded. Thank you.
Thank you very much. Yes, Mr. Malik, anything to reply?
Just very quickly, Milan Friend says that there is, the answer to ground one, Milan Friend says, is that there is actually a finding by the judge that MU is a high-profile member of BNP. That is his submission. He asks you to look at paragraph 34 of the judge's decision, where the judge has summarized the evidence. The evidence was that MU was active in the group. That is the sentence that Milan Friend picked.
I think he said fairly high profile, didn't he?
Yes.
I think that was how he pitched it.
Yes. So the evidence at 34 is that he was he was active in the group, and the judge accepted that evidence at 46 and said that he was politically active. That is the finding that the judge made.
Yeah.
There is no finding that he was a high-profile member or a fairly high-profile member. The finding is that he was politically active, and that finding was not enough to allow the appeal. There is, in my respectful submission, no answer to the third point that I made under ground one, which is sufficiency of protection and internal relocation. Milan Friend accepted that there was no concession by the presenting officer. That being so, there is, in my submission, no answer to that point. Milan Friend says that the situation in Bangladesh is still volatile. He took you to the updated, the current CPIN, and makes a point that the CPIN says that the Secretary of State would not certify an asylum claim. May I just take you to CPIN just to make the point that I'm just about to make, that the situation is volatile for AL members, not for BNP members. So it's tab 2 of the authorities bundle. So I took you, my lords, you'll recall, to page 77, and I showed you paragraph 3.1.1. This is the broad point that is made is that, well, BNP members, supporters, and leaders are unlikely to be at risk. The Secretary of State is making, the CPIN makes the obvious point, puts that to one side. But if you then look at all the paragraphs that follow, they are about supporters and members of AL. So 3.1.2, members of AL are now being addressed by the criminal justice system for what they had done previously. And if you then look at the next page, page 78, the government has a legitimate right to act against criminal activities. This is all about AL members. And the point is that the fact that there is a risk of prosecution for an AL member does not mean persecution. So this is all about AL. And the same is from non-state actors. And you'll see from 3.2.5 that, well, AL supporters are now being attacked and detained. And this is the point that the Secretary of State is making, that, well, if you are an AL member, and then if you look at the heading protection, page 81, again, references to AL, and then in particular 4.1.6, hundreds of senior officials and AL leaders under the former government have been arrested and remanded into custody.
Yeah, okay, we got the point, yeah.
So the point that the Secretary of State is making is that if you are an AL member, a high-profile AL member, I'm not going to certify your claim. But this respondent says that he's a high-profile member of BNP. Surely he's not. He's not at risk. There is no conceivable basis to submit that he's at risk. 12.4 is the paragraph that Miller and Friend.
So sorry, 12.4?
Yes. 12. Sorry. At 12.4.
Harold, this is just to fit this in. This is part of the general country information. The structure of these things is that you get what's called an assessment,
Yes.
which is paras 1 to 6, or sections 1 to 6.
That's right. Absolutely.
Country information, I mean, there may still be relevant stuff in it, but it's not guidance in the same way.
No, no. So the actual conclusions are at paragraphs 1 to 6. From 7 to 13, you have information that essentially supports the analysis that you have at paragraphs at 1 to 6. So if you accept Miller and Friend's submission that MU is a high-profile member of BNP, contrary to what I've said, is still at not risk. Is not at risk for sure on the objective evidence. What actions the Secretary of State can take if the appeal fails is a question that Lords asked. And Miller and Friend quite properly, fairly said that the Secretary of State can decline to give effect to the judge's decision, in effect make a new decision. But what I would respectfully highlight is that in this case, and see the first page of the First Tier Tribunal's decision, page 48, the Secretary of State issued the notice seeking to deport the appellant in July 2021, like 4 years ago.
Mm-hmm.
So it's not that if the appeal fails, the Secretary of State is entitled to put MU on an aeroplane. You'll have to start the process again, issue a decision.
Yes.
So I do ask you to, I mean, of course,
I'm afraid, I think, because we allowed you to make the point you did, then we find ourselves exploring it, but it's not really relevant.
It is not, and yeah, absolutely. So Millards are not
but
going
for
to...
what it is worth, your point is that if the appeal is allowed, if the appeal is dismissed, there are tools available to you, but they will take a long time.
Yes, but of course, Lords are not going to dismiss the appeal on the basis that there are tools available to the Secretary of State to deal with the situation. Very good. That's just one correction, Lord. You asked a question as to whether the judge was right to dismiss the appeal on humanitarian protection grounds.
Yes.
I'm afraid the answer is that the judge was right to.
Oh, right. So what is humanitarian protection? Is that a leftover from EU law?
No. So there is a provision in the immigration rules which essentially says that if you are excluded from the Refugee Convention,
yes,
if there is a certificate under Section 72 of the 2002 Act,
yes,
you are excluded from humanitarian protection as well.
Oh, I see.
And if you need a reference, it's paragraph 3.
Don't worry. It's all just for my education. So Article 3 protection is a separate, a separate creature.
Yeah.
So the judge got that right. That's fine.
So there are 3 grounds that are available to an appellant. First, breach of Refugee Convention. Second, breach of humanitarian protection principles. And C, Human Rights Convention.
Yes, I see.
And if someone has committed serious crime and is excluded, then it's the 3rd ground that is available.
Thank you very much.
Very grateful. These are my submissions.
Well, I think we will rise for a few minutes and just consider where we are. So don't go anywhere. We'll come back into court shortly and tell you how we propose to proceed. Thank you.
clever judge.
Hard working as well.
Yeah.
I think he could go for it. I know years, but not just on a personal level.
Yeah.
So, so diligent, isn't he?
Yeah, absolutely. So I did something where James Eady was leading me, and we ended up before him. He was
Really?
sort of sitting alone, and any UT judge, would have sort of fainted. With the idea of James Eady appearing before him, but did remarkably well, and even James was complimentary, and he's hard to please.
Yeah. I remember being over there once when he was there. He's coming from the court. It was court 10. Shouting.
Yeah.
Sat down. You've never seen him sat down before, either. So he has to sit down. Submissions which were very forceful.
Yeah. How's work?
Oh, yeah. Been away. I did the weekend away this weekend. Glastonbury I went to 2 weeks ago. Yeah. We're both daughters. It's the first time I've been for years. Been funny enough mentioning Mark. It was Mark said to me last year. He said, "You got your Glastonbury?" I didn't get tickets. He said, "Your ears must have been burning." I said, "Why?" He said, "Gaynor and Bruce is going." And so he said, "I said to him, Lucy and Floyd painting.
Yeah.
There's a big one. That was that.
Yeah.
Do you take time off in the summer?
It's just getting up on sittings, etc. Just get time to catch up on sittings. And
Yeah, but vacation when you're primarily here.
catch up on sittings, etc. The Upper Tribunal is fine, but elsewhere, I said, if you don't do your minimums, they sort of send you a polite letter that we are just about to sack you. Do you have anything to say? Say, do you have to sort of do minimums? Just catching up on those.
When does vacation begin? Yeah.
Ian Dove is leaving, so he will be the next president.
He's leaving.
Yes, he's going up.
Oh.
In court of view. Yeah. Just hope that we get someone from within the jurisdiction. This time,
Yeah,
like
I think
Neil
that
Lang.
was some observations when God, giving back. He did used to do some of this work, leading a few people in Birmingham. He was a planning lawyer by trade. I got the impression after the elevation of Peterborough, there was this feeling that this would be the way forward. And certainly with Blackrock, that was the natural progression. I noticed those two were sitting together towards the end of Peter Lang's time. I think it was a big shock that Appleton didn't. So, would now they...
The old experience point is now gone, isn't it?
Yeah, I mean, Judith Gleason, he'll be going soon, Clive Lane.
Yes.
He hasn't got long to go. Jonathan Perkin, I wouldn't have put them.
It has changed completely, isn't it, in the last 2 years, the Upper Tribunal?
Yeah, very much so, yeah. I mean, Mark no, not Mark. He's a chamber president. O'Connor.
Yeah.
I thought Mark insists on deputy.
He says,
So he's very ambitious. Maybe it's a little bit too soon for him. But I know that that's something he's been looking for. But perhaps I can't think of anybody else.
so he's following Peter Lane's
Yes.
steps.
Yeah.
He'll be looking at someone with sort of administrative experience
Yes.
of leading some jurisdiction.
And last time I talked to Mark, I said, meetings, it's admin, as you just said. Because I said to him, I say, I worked for his wife as a solicitor, and I know Mark well, but you know, he just said there's so much admin.
Yeah.
No, I didn't know that.
And they'll appoint some new president as well in the First Tier Tribunal. Melanie is going to go back to the Upper Tribunal.
Is she?
Yeah.
That's what I no, me too early for that. But again, that would stand very good service. In the chain, that president.
I guess someone from the UT would then go and lead in the FTT. Someone like Mark, yeah, who sort of leads it, and then comes back.
Yeah, so not really properly that case, but it just looked really quite interesting. He even when he first got appointed, he was thrown straight into a country guidance case.
Yeah.
Yeah. It's like, do you know what I mean? Give me time to settle.
Yeah.
But I think it was with Jonathan Perkins.
I thought they would want to reserve this.
Maybe they accept what he wants. Did you do the recent Underhill case? It was in the court a few weeks ago. There was another case. That was an appellant's appeal.
Yeah. I know about the case. So the appellant's appeal and the respondent put in a respondent notice
Yeah.
saying that there is now new
Yes.
evidence on this bad point anyway, but they did
Yeah,
not.
yeah.
You can't be putting a respondent's notice relying on new evidence of this sort. I mean, if
You weren't involved.
no. I mean, it's just that someone from Chambers was doing it,
Right.
and they spoke to me about that. So, I mean, surely the new evidence is not relevant to the question of whether there is an error of law. It can only be relevant to disposal or argument. So,
Yeah, it was an odd way, the way I did it.
Mr. Barrett, Mr. Collins, thank you both for your helpful submissions. We expect to be able to give a decision with an oral judgment today, but not right now. I think as a matter of prudence, I will say that we will sit again at 3:30 when we will give you a decision and an oral judgment. And we can deal with any consequential matters immediately following that. So we'll see you again at 3:30.